didn't see you standing, or had you sit earlier? Okay. Good afternoon to everybody. This is an oral argument on the petition of Mohammed Riad and Kevin Timothy Swanson for review of the initial decision of an administrative law judge. A total of 40 minutes has been allowed for the argument, with 20 minutes allocated to each side. Respondents will argue first and may reserve time for rebuttal. Mr. Marshall, do you wish to reserve any time for rebuttal?
Yes, I reserve 5 minutes for rebuttal.
Very good. You may proceed.
Thank you. Sorry, it's a long way. May it please the Commission, my name is Richard Marshall. I'm counsel to the respondents, Mohammed Riad and Timothy Swanson, who are sitting here behind me. The issue here today involves the losses that were suffered by a closed-end registered investment company, the fiduciary Claymore Dynamic Equity Fund, which I'll refer to for this argument as the fund. It lost about $45 million, which is about 45% of its total assets, after Lehman failed in the few weeks at the beginning of the financial crisis. The losses were caused by investments made in short index puts and short variance swaps. And as the initial decision discusses, those investments were made after what the initial decision identifies correctly as thousands of hours of analysis and years of work. And the question that I think I'd like to start with, because obviously with such large losses, the question is, how could the respondents have not known of this risk, and why wasn't it disclosed? And I think the answer to that comes back to finding out what's in those thousands of hours of research. Unfortunately, the initial decision, although it identifies the fact that the respondents saw risk, doesn't explain how the respondents analyzed that risk. And risk is not something like turning a light switch on. You either have no risk or you have terrible risk. There are gradations of risk. And in this case, the respondents started the study about 15 years earlier when Mr. Riad discovered that he was buying long puts, which is really a kind of financial insurance. And he discovered that, based on his calculations, the cost of the insurance was greater than the benefit. So, for example, outside of financial service, you don't pay $100,000 in insurance to insure a $400,000 home for a year. It's not economically wise. That caused him to ask the question, why would that be? And it's fairly well established in the literature that the reason for that is that every form of insurance, including financial insurance, tends to be overpriced. It tends to be something people pay too much for, which is one of the reasons why most insurance companies generally are profitable. Not always, but some. Now, having had that insight, he thought, well, what about a strategy where I'm short sometimes? I'm an insurance provider. I'm writing short index puts, short variance swaps. So I'm making money when the market is overpricing the insurance, and then I'm using those profits to pay for being on the other side, having that insurance when I think market conditions dictate that I need it. He worked with a young associate, Sean Hughes, I think a very able young man, and they analyzed many, many strategies over a period of years. They used something called the Sharpe ratio, which is not ever mentioned in the initial decision, but it's the risk-adjusted rate of return. They rejected many, many strategies that had a very good return, but not a good Sharpe ratio, which meant that the risk-adjusted return was not favorable. And then they did an analysis, which they got, frankly, from the Commission's own rules. Form N2 says one of the ways to evaluate it, whether a risk is a principal risk or not, is by what's called a value at risk measurement. Value at risk is a well-established academic tool to calculate what is the probability of a loss at a certain level in the future. And Form N2 says the level that's relevant is 5%. In the case of this fund, $5 million. So they went back, first doing the Sharpe ratio analysis, then the value of risk analysis, and said, we'd like to find a strategy that has positive returns and where the risk of losing more than $5 million was, in this case, less than 0.5%, which means that they concluded that the strategy had to have a 99.5% level of confidence that it would not lose more than $5 million. Having done that analysis, they came up with a strategy. The strategy was sometimes be short index puts and variance swaps, sometimes be long. And they would do it deep out of the money. So for example, with an index put, let's suppose today the S&P 500 is at 2,000. They would write a short index put at 1,700. They get a premium when they do that, and they keep that premium whether the option is exercised or not. If there was less than a 0.5% chance of the market going below 1,700, they keep the premium, they lose nothing, and they make money. And in fact, over and over again, before the financial crisis, that's exactly what happened. Even when the market went down, they made money. The same principle applies with variance swaps, although it's a bit more complicated. I'm sorry, you have a question?
Yeah, no. What time horizon did they use for their value at risk measure, right? Because value at risk says it's 0.5% over a certain time horizon, right? So suppose it's a 10-day or 30-day, whatever it is, and then you roll those into multiple strategies over time. It's 0.5% on each one of those time periods, and that adds up to something potentially significant. What time horizon did they use?
They used the time period during which the instruments that they were buying remained open. Generally 30 days, sometimes a bit longer. But what they looked at is what was the probability during the time horizon that they were looking at. During the trial, there was testimony that both the respondents and the division had experts. Both were former chief economists of the SEC, both professors of economics. There was a question about the historical data that was looked at. For index puts, for example, they went back to 1928, and there was a question, should they have gone back to 1905 or 1890? But there was a dispute about what an academic standard would have been, a standard of reasonable care. But they looked at the relevant value risk calculation, which I believe is what 4N2 dictates, which is a period when the position was on the books. After they did the years of work, and the initial decision says many years, thousands of hours, they started the process. Now, Mr. Riad said that he asked the chief financial officer of the advisor to the fund whether he could do it. And what has to be remembered is Mr. Riad and Swanson were employees of FAMCO, the sub-advisor. Claymore was the advisor, which meant that Claymore prepared the filings with the SEC. They made the filings with the SEC. Claymore had a law department. FAMCO had no in-house lawyers. Claymore had years of experience with registered investment companies. FAMCO had never been anything other than a sub-advisor, and only for a couple other funds before this fund, and only for a couple years. So naturally, Mr. Riad reached out to a greater expert at Claymore and asked, can we do this? Mr. Hill did not remember the question being asked about short index puts, although the fund put on a short index puts just a few weeks after it was launched, and many thereafter. But Mr. Hill did remember the question being asked about variance swaps. Is it okay to do it? And the answer that came back was, it is okay. We think it is significant that Mr. Riad also invested his own money in exactly the same strategy, only after the years of research. FAMCO had a private fund, a hedge fund, only open to the friends and family of FAMCO. And Mr. Riad managed that fund. He invested his own money in this strategy. Just like the fund, when Lehman failed, he lost a quarter of his life savings. Mr. Sean Hughes, the young assistant who did the work with him, also invested his own money. He wasn't eligible for this house fund. He invested in the fund itself, and he also lost money on it. They put their money exactly where their mouth was.
You'll probably get to this next, but in addition to the outreach, the thinking on permissibility, if we can call it that, what was the outreach discussion thinking on disclosure?
Right. Well, that gets to an event which we think actually is helpful to us, which is that when Mr. Riad began to put on the trades, a fund accountant, Jeffrey Grossman, questioned whether they were permissible under the disclosures. There's no evidence that anybody tried to prevent him from making that claim or elevating it, and in fact, it was taken to Claymore. And in January 2008, there was a conference call. Every participant on that call testifies that they were told that fund counsel, Tom Hale, had been consulted, and he had said, these are permissible investments. Mr. Hale, at the time, was the co-head of the investment management practice at Skadden Arps, one of the preeminent investment management lawyers in the world. And Mr. Hale both submitted an affidavit and at trial testified that he never would have answered a question about permissibility without also considering the disclosure implications. It's really hard to imagine that a lawyer of the stature of Mr. Hale, when asked, can we invest in index puts and variance swaps, he would say, well, it's permissible, but you can't do it because you haven't disclosed it. And in fact, he both gave an affidavit and testified he would include both of those themes. Now, the disclosure issue is an important issue. It was very prominent in the judge's decision. The judge said this was a covered call fund. There was not adequate authorization for these investments. There was not adequate disclosure of the risks associated with the investments. First, what did the documents say? What the initial decision neglects to point out is that in November and December 2008, after all the trades had settled, all the losses were known, the board of the fund asked Mr. Hale to analyze whether the conduct had violated the law in any way. In the record, undisputed, is a memo Mr. Hale wrote, in which he concluded there were no violations of law. The disclosures permitted these investments. And not only Mr. Hale, a preeminent lawyer, he wrote the disclosures. So the author of the disclosures said, these are okay, this is how I read this. And in the minutes of the board meeting, it confirms, based on Mr. Hale's advice, this was deemed to be permissible. Another point where there was consultation, there's a debate about whether the description of these transactions as hedges, the respondents talked about them as hedges when they talked to the board, when they gave these interviews that were in the semi-annual annual report. They talked about it as a hedging strategy. Well, first, a strategy is different from a trade. And as I said, sometimes long, sometimes short, you have to look at the whole package. You also have to look at the fact that in declining markets, they made money up until the financial crisis. But this very issue was describing this as a hedge okay was raised within Claymore. And the initial decision says, oh, the chief financial officer of Claymore wrote an email to the lawyer at Claymore asking if these were permissible to be described as hedges. That shows he didn't understand them. I think if you read the whole context of the email, the chief financial officer of a large money management firm is not asking an in-house lawyer, how does a variance swap work? Is it a hedge? He was asking, is the legal disclosure adequate? And what was the response? I am comfortable with the disclosure. So consistently, there was disclosure to the lawyers, and the lawyers consistently said, this looks okay. Now, you might ask, how can that be? How can there be all of these losses when these people didn't disclose, these were very risky, this is very dangerous? It comes back to the analysis. They disclosed what they believed. They did not believe that these were high-risk, dangerous, uncontrollable strategies. And in fact, that's where they put their own money. They put their own money behind that. What went wrong? How did it fail? Well, it failed because of the financial crisis. And in fact, after Lehman failed, the market moved in unprecedented ways, both in terms of the declines in stock prices and the increase in volatility, which not only was elevated, but elevated for unprecedented periods of time. And remember, every investment has risk. Their analysis didn't say it's 100% guaranteed that there won't be any losses. If they'd included that, they would have been fools. What they concluded, there's a 99.5% probability that the losses will be less than 5%, and therefore they're not material risks. And that's really the test. It might be said that that's a poor test. In fact, the government's, the divisions expert, I keep calling the government, the divisions expert, said, well, value at risk is a very poor test. It's not the right test. And that may be true. But at the time that these decisions were made, it was the published guidance of the commission, and actually it is the published guidance to this day. Now, they did other things to control risk. As I said, sometimes they were long, sometimes they were short. If they'd been long when Lehman failed, they would have made money. They would have had the insurance and they would have been fine. They used a macro analysis to determine when to be long and when to be short. They used the value at risk measure to size the positions. They didn't just go into the market and say, oh, we'd like to be short index puts, and then the counterparty said, how much? And they said, we have no idea. They used value at risk to size the position. And also, they relied upon Section 18F. There is no dispute. Mr. Hale opined, the division has not alleged that 18F was violated. 18F is the provision, as the Commission well knows, that permits derivative investments if there is the cover done. And that was done in this case, and they took additional comfort from that as well. So for all of these reasons, I think when you come back to it, the respondents believe that they act reasonably, not even negligently. And I guess finally I would just note there was, in the initial decision, a long discussion about the question and answer sections in the periodic filings. One is for the annual report for the period ended November 30th, 2007. The second for the semi-annual report for the 6 months ended May 31st, 2008. For the one that ended in 2007, unfortunately, the numbers are just wrong. Repeatedly, the initial decision says, and I see I'm out of time. Can I finish?
Yes, please
Okay,
finish.
thank you. The initial decision says 45% of the performance came from short-ended puts and short variance swaps. It's a mistake. The initial decision grouped all of the derivatives together, including the covered calls that aren't at issue here. It's more like 15%. Secondly, the initial decision says, well, they gave an example of a particular security, and that didn't perform as well as, let's say, the short-ended puts. But I think when you read the context of the narrative, the examples are given simply as illustrations. For example, we're doing well in the tech sector, such as in Apple.
Thank you very much.
Thank you.
We'll hear from the division, Mr. Moy.
Good afternoon. Although the investment products at issue in this case were complex, the question regarding the conduct of respondents...
Is your mic on there?
I hope so.
Okay, we can hear you now.
The question about the conduct of the respondents at issue is relatively simple. Respondents, as portfolio managers, changed the strategic objectives of the fund and strategy to invest in risky derivative investments. They did this without disclosure to investments, without disclosure to investors, to fund counsel, or to the board. They misled them, and they said that their change in strategies would help to mitigate against volatility and add additional downside protection when they knew this wasn't true. Rather than hedging the portfolio, what they did was they transformed a safe and conservative covered call fund into the equivalent of insurance against declines in the markets, which were sold to other people looking for hedges. And in the fall of 2008, the fund collapsed because of the use of this strategy. Now, as you know, the respondents complain of 4 basic mistakes that they think the law judge made. They said that they had broad latitude to invest in these type of investments under the fund documents. They said that they reasonably believed that there was a very small potential for loss. They claimed that they openly disclosed what they were doing regarding the strategies and performance and risk to all interested parties, including investors. And finally, they claim that they have the basis to establish a reliance on counsel defense. Well, none of these arguments can actually be reconciled with the evidence in the case, which was produced at the hearing. So I'll address each of these strategies in turn, and if time permits, I'll address scienter and the need for sanctions. First, there's no real dispute that this fund was conceived, organized, and marketed as a covered call fund. Respondents themselves often referred to it as a covered call fund, and they measured its performance against the BXM covered call index. Now, respondents claim that they were allowed to use various types of derivative investments, including the ones at issue in this case. But this argument is essentially a diversion, because the issue in this case is not whether their actions were ultra-virus, but whether they appropriately disclosed what it is that they were doing. The Commission's Form N2, as you know, requires that closed-end funds disclosed in either registration statement or in annual reports principal investment objectives and policies, practices, and risks. This they did not do. The registration statements describe a traditional covered call strategy. And according to Tom Hale, the fund's counsel, the term dynamic in the fund's title merely signifies that the fund had additional flexibility in using its call option strategies, including the use of call-on calls, in-the-money calls, and the percentage of the portfolio that would be covered by calls. As you know, covered call strategies tend to be popular among retirees and conservative investors because they generate steady income, but also because they're generally protected against volatile markets more so than pure equity strategies, and they tend to outperform equities in down markets. The investors here simply did not understand from the initial registration documents or from the annual reports what the portfolio managers were doing with these derivative investments. These documents focused on the fund's covered call investment strategies, and even though they mention a number of possible other strategies, these were never described to investors in the way they were used. In fact, the term variance swap never occurs anywhere in the fund's registration statement. There's only a single sentence that says that the fund might buy or sell put options, and this single sentence is part of a paragraph called strategic transactions. Fund counsel testified at the hearing that this strategic transactions paragraph was boilerplate, included in nearly every fund prospectus he drafted, and that he thought there should have been more disclosure about the fund's derivative strategies. Now, the fund's contemporaneous marketing materials also made no mention of the strategic transactions when describing to investors how they would be invested. The disclosure of risk in the prospectus didn't discuss any of the risk that would be associated with the use of derivative investments, so these were clearly inadequate. I will get to disclosure in a minute, but based on these failures to describe the strategies that Riad was anticipating that he might use going forward, they had to disclose to investors in the annual reports when they began using them. Now, turning to the question of risk, respondents both knew that the use of these derivative strategies increased the risks that were run by the fund. The goal was to pay investors a dividend of 8.5% of the initial offering price. They needed 10% earnings every year before fees. So they eventually implemented this derivative strategy in order to increase the earnings of the fund. It was intended to generate, as my colleague said, it was intended to generate additional premiums or income over time, but they took on additional risk in order to gain that additional income. This was a fundamental change in the fund strategy for two reasons. First, they expected that the use of puts and swaps and short variance swaps would help them meet their primary investment objectives of generating income. In other words, they expected it to be successful. But more importantly, they knew that there was increased risk of loss because they had done the research. All of the research which Riad and Sean Hughes had done into the use of these various types of investments showed that while there was a probability of steady gains, there was also the possibility of large and unexpected losses. This was a crucial factor because this fund, as a closed-end mutual fund, it distributed its gains quarterly. There was never any cash reserves. There was no way for them to handle or pay out the insurance claims as they've been described. If you're selling insurance to people and you get a flood or a tornado or an earthquake, you've got to pay out claims, and there was no way for the fund to ever do this. Sean Hughes, Riad's portfolio analyst, conceded at the hearing that the research showed that the types of market losses that they experienced in the fall of 2008 were not unprecedented. The S&P had suffered similar declines in the past, and the fund would have suffered losses several times based on its exposure to these particular investments. In fact, Hughes warned Riad about potential for losses due to large spikes in volatility that occurred regularly over time. And in a memo to the board in the fall of 2008, the portfolio managers themselves noted that although they suffered big losses, these losses were not out of line, they were in line with what their prior analysis had shown that their loss exposure might be. Professor Harris, former SEC economist, was our expert witness. He performed stress testing, and he thoroughly debunked this idea that there was only a 0.5% chance of a 5% loss. He confirmed that respondent strategy would have suffered significant losses at various times in the past recent history, including 1987, 1998, 2001, and 2002. In 3 of these 4 market declines, the losses of the same investments that the fund had would have resulted in double-digit losses, and in 1987 it would have been nearly a 50% loss in the fund, even higher than what the fund actually experienced here. Swanson himself recognized the risk associated with written puts and variance swaps because on at least 2 occasions, in September and November of 2007, he communicated with Riad through instant messages saying, maybe we should take off some of this some of these derivative investments to reduce our exposure in the fund, reduce the potential for loss. But both times, Riad persuaded him they needed to stay in them, they needed to ride it out, or they shouldn't unwind the position now. And of course, Jeffrey Grossman, the fund's accountant with substantial experience trading options, came to Riad multiple times and warned him about the risks of these uncovered written put options. Riad dismissed each of these warnings, and the only reason that the question was ever elevated to Claymore in January of 2008 was because Grossman went over Riad's head and insisted that he needed to get compliance involved. Now, in their briefs, respondents complained that the law judge disregarded the testimony of Professor Spat. I won't spend much time here, but I'll just point out that unlike Professor Harris, Professor Spat actually didn't do any stress testing or analysis of his own. He looked at the testimony from the investigation, he looked at the well submissions, he looked at other documents, but he didn't do any analysis himself. Therefore, that's one of the reasons why during the hearing he was forced to admit that one of his key assumptions was incorrect. And Professor Spat simply couldn't explain why they made certain adjustments to their probability assessments, and he openly acknowledged that he didn't take into account the issue of cumulative risk. When you keep investing in these things over time, it's not appropriate to look at them as a slight, remote chance of a loss because it's a one-off investment. So turning to the issue of disclosure. Respondents had a responsibility to manage the fund in accordance with the initial documents, and to the extent they made any changes, they were responsible to disclose that in the annual reports. In fact, these were the perfect opportunity to do so. They began using these strategies in April of 2007, and they began using written puts without substantial cover with offsetting long positions in about October and November of 2007. Investors should have been given the opportunity to evaluate whether they wanted to continue investing in this fund or try to sell off their investment if it turned into something different than they had anticipated. The new investment strategies altered the principal risk, and accordingly, the fund portfolio managers had an obligation to speak truthfully when they participated in the interviews, which resulted in the Q&A sections of the annual report. Unlike other annual reports, this one actually had a Q&A section with the portfolio managers based on interviews which were recorded and which were played at the hearing. Swanson was the one who participated with Patty Deloney, a financial writer hired by Claymore. And his statements to her were misleading. He sent her attribution reports before the interviews, which left out the performance of these specific derivative investments. He never mentioned in either of these two interviews in 2007 or in 2008 that these strategies had been important to the success of the fund during those periods of time. He never discussed any risk. And to make it worse, he described what they were doing as part of a hedging strategy, one designed to mitigate risk, when he knew that that was not the case. He touted their performance as stock pickers, and he explained that the main success of the fund could be described based on the covered call strategies. He even described some minor investments that the fund had made as particularly successful or unsuccessful when he had full knowledge about how the derivative investments had affected the fund both for good and for bad. All of these statements are detailed in our briefs, and I won't go through them here. But I did want to point out that both of these individuals, both respondents, had the opportunity to review Patty Deloney's written presentation before it was submitted for filing, and they both either corrected or had the chance to correct it and make edits. They failed to do so. In fact, they didn't reveal what they were actually doing with derivatives until the fall of 2008, when the fund had collapsed. At that time, they were asked to help draft a press release to the public about why the fund had experienced this sudden collapse in value. Riad sent Swanson an email in which he demonstrated that he had never told anyone enough about what they were doing with these strategies. He said, "I decided to be upfront and explain these strategies instead of hiding." Obviously, if Riad had believed that they had told investors, board members, fund counsel, and their Claymore advisor what they were doing with these strategies, including the size, the duration, the risks, and what they were actually being used for, there would be no need to make that disclosure. But there was an additional problem. Riad still didn't come clean. In fact, when he went to the board and explained what he had done, explained the use of variance swaps and uncovered written puts and how they had affected the fund, he lied to them. He said that what he had done was he had used these written puts in conjunction with long put positions. This simply wasn't true. The long put positions were only in place for part of the time, and for far more of the time, the funds were uncovered. He also continued to explain that they were doing this to reduce portfolio volatility, when respondents both knew they were doing it to generate additional income for the fund. This was admitted in a fall of 2008 application for the renewal of the sub-advisor's permission to remain a sub-advisor. They said that we had used these funds, we'd used these strategies for our fund to increase the income. A few words about respondents' expert Jay Barris on disclosure. Respondents claim that the law judge ignored him, but this is not problematic. This is a lawyer. He was testifying about what the law is and about what he thought the funds normally do with respect to the law. This is consistent with the Commission's longstanding policy of disregarding legal opinions offered in administrative hearings. And finally, Barris's opinion was not always helpful to respondents. He testified that portfolio managers should have disclosed what they were doing with the derivative strategies to investors and the board, and that portfolio managers should have explained how these derivatives directly affected the fund's performance, and they didn't do this. In a moment, I'll move to advice of counsel. But I want to talk a little bit about Tom Hale. A complete picture of what Tom Hale actually did, the fund's counsel, can best be gained by reviewing the whole record and not simply relying on what respondents say in their brief. Tom Hale denied that he ever rendered an opinion about disclosure. He was specifically asked that during his testimony at the hearing, and he said, in fact, I have problems with the disclosures here. If you look at the memo which counsel referred to, it simply doesn't talk about disclosure. It doesn't issue an opinion on it. And the only people that they've claimed have issued opinion on disclosures were the results in short emails where these people never had the full picture of what was actually going on, how these derivatives were being used, what their success was, what their problems were, and what the risks were. So on the issue of advice of counsel, respondents cannot and should not be permitted to establish a defense on the advice of counsel. They didn't tell anyone the extent to which they were using derivatives. They didn't describe them as a strategy. They didn't ask anyone to review their disclosures with an eye to whether they're making sufficient disclosures, the types that investors needed. They described the practice as hedging, and they never asked anyone to opine about that. And they certainly never gave anyone the facts that they would have needed to evaluate in context and give them real legal advice. In fact, there's no direct communications between respondents and counsel at all. They tried to run it a couple of times through Claymore, and respondents have a different version of what they said they asked than what the other witnesses remember. With regard to the January 2008 telephone conference, there's a written record of that telephone conference. It's a memo written by one of the participants shortly afterward. First of all, it doesn't say that Tom Hale participated, but whether Hale or one of his colleagues at the firm participated or not, it shows that the subject of that discussion was whether it was okay to put on a written put position, not whether to use these as a strategy, not whether the disclosures were appropriate, and certainly not whether the risks were appropriately disclosed. Several participants on the call contradict respondents, and they say that there was no discussion of any disclosure issues, and certainly no discussion of how the portfolio managers were using these investments as a strategy. Moreover, this telephone conference took place more than 6 months after respondents had begun using derivative investments, which belies any possibility of establishing a reliance on advice of counsel defense. And it's well established in the law that reliance on counsel is only one factor to be considered in evaluating scienter. Here, respondents had sufficient industry experience that they did not need advice of counsel to tell them not to lie to investors. They didn't need a lawyer to tell them that their disclosure should be sufficient and should describe the strategies, the risks, and the performance of these investments. They didn't need a lawyer to tell them that their statements to the fund board and others about how they're using these investments were truthful. Turning to the issue of scienter.
Just to interrupt you for a second, but it's also your position that the lawyers didn't tell them that.
That is our position. We think that's a fair reading of the evidence. In fact, there's no evidence that Hale consulted with them personally, or he told them that this is an appropriate strategy, that these derivative investments can be described this way, or that it's in line with the registration. I'm sorry. The only thing that we know that counsel ever rendered opinion on, because he wrote this in his memo after the fact, was these were not ultra-virus investments. He said these were permitted. But saying something is permitted is a far cry from saying it was appropriately disclosed. And if they had simply done a one-off investment in one of these products, we wouldn't be here today. They adopted it as a strategy without disclosing it to investors, to fund counsel, or the board. And this, I think, is a primary evidence of their scienter. Look at what they told the board. They had every incentive to tell Claymore and board members exactly what they were doing. If, in fact, they reasonably believed that there was low risk of loss, they should have told Claymore that. But you can't find it. It's not anywhere in the documents. Swanson personally withheld information about positive and negative results of these strategies from Patty Deloney. He referred to the fund's use of derivatives as a hedging strategy, which it was not. These strategies actually amplified the fund's risks in precisely the same way, precisely the same market conditions that would have hurt a covered call fund. It was the equivalent of leveraging up or borrowing money to invest in more covered calls. It's the opposite of a hedge. And Larry Harris thoroughly debunked the idea that this was used as, could have been called or was used as a hedge. It was being used to generate income. Generating income in the same way that a covered call generates income is not a hedge. It's just not. Riad knew from his own research that there was a possibility of significant unexpected losses in using these strategies, and yet he wanted to use them anyway. Whether or not he thought the risk was remote, he had the research which showed that these events would occur regularly that would have incurred losses, and he chose to disregard it. And Riad told the board repeatedly that these funds were being used as a hedge, which was not true, and he told them that he had used them in combination with long put positions, which was not true most of the time. Respondents benefited personally by not revealing that they had transformed the fund from a conservative covered call investment to a riskier derivative fund in several ways. They preserved their ability to measure the fund against its covered call benchmarks and beat those benchmarks. They achieved the fund's aggressive dividend strategies. They avoided an investor exodus, which would have occurred from some of the investors that could not invest in this type of derivative fund. They solidified their firm's continued retention as Claymore's sub-advisor, and they preserved their own position as portfolio managers. Accordingly, they each acted intentionally or recklessly, and they need to be held accountable. So turning to the issue of sanctions. Respondents' conduct in this case is very similar to a 2003 decision of the Commission called Fundamental Portfolio Advisors. And I encourage you to look at that case in which the Commission affirmed the imposition of significant third-tier penalties in an industry bar against a portfolio manager who changed his fund's investment strategy without disclosure to investors. Thanks.
Before you actually sit down, if I could just ask on the 45% error issue, do you agree with that?
I did not get to it, Your Honor. Frankly, there's no real evidence at the hearing to support respondents' argument. What I would say is what they said at the hearing was that of the 45%, any long put or offsetting positions were only a small part. The derivative investments were the largest portion of that 45%.
Thank you, Mr. Marshall. You can proceed with your rebuttal.
I'll try to take each one in turn, and I have very little time. Mr. Moy said that these were principal strategies and principal risks. He didn't mention the law. The initial decision doesn't mention the law. There's a definition in the law. How much of the assets were invested in this strategy? Less than 1%, undisputed. What was the risk of losing 5% or more? Less than 0.5%. That's the definition in the law. Mr. Moy mentions the fact that the prospectus didn't mention variance swaps. That's an interesting story. Let me tell you the story. When they started using variance swaps, Claymore said, we need to put a narrative disclosure in the periodic filings describing how variance swaps work. They did it, and then when the board received those periodic reports at their meetings, that was highlighted on the cover as a material change, a description of how they worked and what the positions were. Let's talk about risk. I disagreed with every single thing Mr. Moy said about the experts and all this stuff about emails about risk. Unfortunately, there's nothing in the initial decision either way. The initial decision noticed that there were experts from each side, no discussion of what they said, what was concluded. The fact of the matter is that every investment has risk. The question is, how do you quantify the risk? Not the fact that somebody said this is risky. How do you quantify it? And then this thing about the incentive to keep up the dividend, this was not even mentioned in the initial decision because it doesn't hold up. Mr. Riad recommended that the dividend be cut, and it was cut in July 2008 before there were any losses of any kind, when this thing was working beautifully. So this pressure to put on the dividend, this case is about the first trade that was a big loser. It was August 15th, 2008, and then the ones thereafter. The dividend was already cut before then. Let's talk about the Q&A, about, oh, everybody was concealing things. The theory here is a little bit convoluted because the theory is they were too bashful about how good it was going. They've kind of, in order to try to find a lie, they've tried to say, well, they should have been more boasting about how well this performance does. We can talk about the numbers and all this kind of thing, but that's a very strange kind of motivation, particularly since you can imagine it if there was a cover-up. But every single filing, they have a separate section, and these filings are 20 pages long. There's a separate section, short index puts, variance swaps, highlighted, described. Where's the cover-up? And the theory that they had to keep this completely secret from everybody because if it was discovered it would be stopped, and that's why they weren't boasting about their success, isn't it more credible that they didn't say something they didn't believe? They didn't believe that these were highly risky or likely to be significant contributors to success. If they'd been boasting about something they didn't believe, we'd have another case. Finally, let's talk about Mr. Hale. Mr. Hale wrote an opinion in late 2008. He was asked by the board, any violations here? He said, no, it's in the minutes. And then he put in an affidavit and testified at trial, which any preeminent lawyer of her stature would obviously do. He wouldn't say, okay, but I didn't tell you, it's illegal because you didn't disclose enough. What competent lawyer would give advice like that? It's just an incredible theory. And then finally, this thing about profiting from their lies. This is a closed-end fund. Good performance, no more fees. Mr. Riad lost a quarter of his life savings on this strategy. Mr. Hughes, a young analyst, lost a significant part of his life savings. They actually believed in this. And in fact, when you go to the disgorgement, Mr. Swanson was he had a very minor bonus. He was basically on a fixed salary with a very minor bonus. Mr. Riad, he did many things. He didn't profit from that. That's why the disgorgement number, you've got $45 million losses, a fund collapsing, and you've got $118,000 in disgorgement. Even that, we think, is overstated. But there isn't even a theory to show a financial motive here. In the Stedman case, the D.C. Circuit said, if you were going to imagine these people were acting out of fraud, they must have been doing it just for the pleasure of it, because they made not a penny off of it. So I don't think that this motive of profit to lie holds up. And I guess finally, since I have a few seconds, we've talked about this issue of hedging. It worked as a hedge. The Claymore lawyer says it was properly described as a hedge. I looked high and low for a definition in the commission rules or commission cases about what a hedge is. I couldn't find it. Professor Spat, former chief economist of the SEC, has a position that makes money when the market goes down. I call that a hedge. Thank you very much.
Thank you, Mr. Marshall, and thank you all counsel for your participation. The commission will take this under advisement. We are adjourned.